Welcome to the Courtroom Club. Right, let's talk about that envelope. You know the one. Lands on your kitchen counter, stamped with the court crest. And instantly just this cold wave of dread hits you. We're talking about getting a summons for debt here in South Africa. It's honestly one of the most stressful bits of mail anyone can receive. And the immediate reaction. Often panic, maybe paralysis. But look, our mission today, our whole goal is simple. We want to strip away that panic and replace it with a clear, strategic legal action plan drawn straight from the insights what our team uses every single day.
Exactly right. Our goal in this deep dive is really to synthesize the critical advice, the best practices we see constantly in litigation. We want to make sure that you, our listener, can quickly get up to speed on the legal process. We're focusing specifically on those essential steps you absolutely have to take, like right now. How to formally respond to that summons and, proactively protect your credit profile, your financial standing.
Okay, so let's start right at the beginning. For someone who's never seen one before, what actually is a summons, fundamentally? And why does it feel so, well, intimidating?
A summons is basically the official start of a legal battle. Think of it like that. It's a formal legal document issued by a court, and it tells you that a creditor, they're called the plaintiff, is starting legal action to get back money they believe you owe them. And it's intimidating because, well, it shifts the whole thing. It's not just angry phone calls anymore. Now it's in the formal court system where the stakes are, frankly, much higher.
Got it. And when you get this stack of intimidating papers, what are the absolute must-find details, the things you need to locate immediately?
Okay, there are 4 non-negotiable pieces of info. First, the exact amount they're claiming. You need that number. Second, who is the plaintiff? Which creditor is actually suing you? Third, the statement of claim. This basically says why they think you owe the money. Is it an old car loan, a credit card? What is it? And finally, the absolute most critical date on there, the return date. That's your deadline. Your official response must be in by then. Missing it. That's catastrophic.
Right, let's talk about that catastrophe. Because freezing up, doing nothing, it feels like the easiest path sometimes, doesn't it? But legally, it sounds like the worst thing you can do. What actually happens if I just, ignore the summons, miss that return date?
The stakes are incredibly high, really, because the consequences can be almost automatic. If you don't respond, fail to act, the creditor doesn't really have to prove much. They just apply for what's called a default judgment, and most likely, the court will grant it. And that means the court has officially agreed you owe the money. You've basically forfeited your chance to argue, to dispute the claim, or even negotiate better terms.
Wow. And once that judgment is granted, the creditor suddenly has a lot more power, legally speaking.
Precisely. That judgment gives them the legal green light to enforce the debt. And the methods can be, well, quite devastating. We see it constantly. Wage garnishments, that's where money comes directly off your salary, often without you needing to agree. It also means the sheriff can get involved. They can be authorized to attach your movable property.
Movable property? Like what?
Things like your car, maybe household goods, furniture. They can seize it and sell it off to recover the debt amount.
Okay, that's serious.
And it goes without saying, this whole process absolutely trashes your credit profile. Long-lasting damage. It makes getting housing, future loans, even some jobs much harder.
Right, that makes it crystal clear. Doing nothing is basically like signing away your rights down the line. Okay, let's unpack this then. We need to swap that panic for a proper plan, a structured legal response, starting from the very first moment that summons is in your hand. What's step 1?
Step 1 is immediate triage. Read it. Understand it. Don't just shove it in a drawer. You need to immediately pull out 3 key things. Jot down the total amount they say is owed. Find that all-important date you must respond by. Remember, it's usually 10 court days from service. And note down the court name and the case number. That info is your foundation for everything else.
Okay, step 1. Get the key facts down. Step 2 sounds critical, and you hear this all the time, but maybe people hesitate. Get legal assistance immediately. People worry about the cost, right?
Yeah.
But delaying seems like it just shrinks your options.
Absolutely. It has to be immediate because you've only got that very tight 10-court day window. Step 2, calling a legal professional, it really needs to happen almost instantly. Otherwise, you simply won't have enough time to properly execute step 3.
And for someone listening who is paralyzed by that potential cost, where's the first place they should look for accessible help?
Okay, good question. Start with Legal Aid South Africa. They're set up for this. Or look for local pro bono legal clinics. Many offer initial consultations, sometimes free. The key is, don't let fear of cost stop you from getting advice right now, especially when things are so time sensitive. A lawyer can explain your rights, your options. Honestly, the cost of not getting advice at this stage could be far, far higher than a consultation fee.
Right. So get advice, then comes step 3, which sounds like a major decision point, a fork in the road, deciding whether to actually defend the claim or acknowledge the debt.
Exactly. This decision dictates your whole strategy going forward. Path A or path B.
Okay, hold on. If I actually know I owe the money, why would I even think about defending it? Isn't defending only for people who think the claim is totally wrong, like the amount's incorrect or something?
That's a really important point. Path A, the defense route, it's actually for a couple of situations. Yes, definitely A. If you genuinely dispute the debt itself, maybe the amount is wrong or you've already paid it. But also B, if you believe the legality of the claim is flawed. And this is where some hidden opportunities can sometimes lie, even if you did originally borrow the money.
Hidden opportunities. Tell us more about that, especially for someone listening who feels like they owe it and there's just no way out.
Well, a big one we often look at is prescription. Debt prescription. It surprises many people. Just because you haven't paid a debt doesn't mean the creditor can chase you for it forever. In South Africa, many common consumer debts prescribe, meaning they legally expire. Usually that's after 3 years, provided, and this is key, provided there hasn't been any formal acknowledgement from your side or any payment made during that 3-year period. If we can successfully argue prescription, the whole summons basically collapses. The debt is unenforceable.
Wow, okay. That's huge. Prescription. Are there other kinds of legal technicalities that could potentially invalidate a claim, even if the money was borrowed way back when?
Yes, definitely. We often look at compliance with the National Credit Act, the NCA. Did the creditor follow all the rules? For instance, did they properly serve you with what's called a Section 129 notice before even issuing the summons? Sometimes they mess that up. Or potentially, was the original credit agreement itself maybe reckless, given your circumstances at the time? If your legal advisor finds any of these potential defenses, prescription, NCA issues, whatever it might be, then you absolutely must file what's called a notice of intention to defend, and you have to do it within those strict 10 court days. After filing that notice, you then prepare and submit your formal plea, which outlines exactly why you believe the claim is invalid.
Okay, so path A is the fight path, using legal grounds. Path B, then, is the acknowledgement route. That sounds more like focusing on settlement or managing the debt somehow.
That's right. If you acknowledge the debt is valid, or you choose not to defend it on legal grounds, the smart move is usually proactive. Contact the creditor, or more likely their attorneys, and try to settle. Maybe negotiate a reduced amount or at least a manageable payment plan. Doing this is often much better than just waiting for the court to impose terms on you through a default judgment. And importantly, if you look at this debt, plus all your other debts, and realize you're actually deeply over-indebted, this is the moment to seriously consider applying for debt review.
Debt review. Can you explain that quickly? What power does that process give someone facing this summons?
Debt review is a formal legal process under the NCA. It's quite powerful. It essentially presses pause on legal action like this summons, and it allows a debt counselor to assess all your debts and work out a single, consolidated, affordable monthly payment plan. This plan then usually gets approved by the court. It acts like a shield, protecting you from further legal enforcement like wage garnishments, while you systematically pay off your debts under that structured plan.
Okay, so whether you choose path A, defend, or path B, acknowledge, settle, debt review. Step 4 seems like it applies no matter what. Document everything.
Oh, absolutely critical. We cannot overstate this. Every single interaction needs a paper trail. Every phone call. Make a note date, time, who you spoke to, what was said. Better yet, follow up with an email confirming. Keep every email, every letter, every settlement offer, proof of any payments made. File it meticulously. This documentation is your evidence. It's vital for proving what was agreed if the creditor tries to backtrack later, or, like we mentioned, it can be crucial for proving when the last payment or acknowledgement was for prescription defense. Keep everything.
Got it. Document, document, document. And finally, step 5. This applies if you've gone down path A, decided to defend, and things are actually heading towards a court hearing.
Yes. If settlement fails and the matter proceeds, you need to prepare for court. Your attorney will obviously guide this preparing evidence, framing the legal arguments. But the one thing you absolutely must commit to is attending the hearing, if it gets that far. Missing the court date, even if you filed all the paperwork, that's a huge risk. A judgment could potentially still be granted against you in your absence. You need to show up, be prepared, participate.
Okay, we've laid out the action plan, but I want to pause here for a second. Because even when you're planning your defense or negotiating, you still have rights, don't you? The law still protects you in certain ways.
That's right. And what's fascinating here, perhaps just important to remember, is that facing legal action for debt doesn't make you a criminal. You aren't powerless. You have fundamental rights. The right to receive proper legal notice, that's what the summons is supposed to be. You have the right to dispute the claim if you have evidence. You absolutely keep the right to try and negotiate a settlement. And, of course, the right to get legal representation to help you navigate all this. Knowing these rights helps you stand your ground, ensures you're treated fairly during the process.
Right. Let's quickly bust a couple of myths then, because anxiety breeds misinformation, doesn't it? Let's tackle the biggest fear first. Can I actually be arrested in South Africa if I don't pay this debt?
Absolutely not. Unequivocally, no. This is such a common fear, and it's completely unfounded in South African law for standard consumer debt. Debt is a civil matter, not a criminal one. You cannot be arrested, you cannot be imprisoned simply for failing to pay a debt. The consequences are financial, procedural like we discussed, judgment, garnishments, but not jail.
Okay, that's a huge relief for many, I'm sure. We mentioned the 10-day deadline. Let's just clarify that time frame again. When does the clock officially start? And what kind of days are we counting?
Good clarification. The clock starts the moment the sheriff properly serves the summons on you or someone at your residence or place of work authorized to receive it. And we are counting court days. That's important. Court days usually exclude weekends and public holidays. Sometimes there are specific recess periods too. But honestly, regardless of the exact count, 10 court days is an incredibly short time in legal terms, which loops back to why step 2, getting that legal advice immediately, is so vital. Needs to happen on day 1, really.
And what about negotiation? Say someone's past the initial panic, they've got the summons, maybe they even filed a notice to defend just to buy time. Is it too late now to try and settle things peacefully?
Not at all. It's almost never too late to negotiate. Many creditors, or rather their attorneys, actually prefer a guaranteed settlement, even if it's for a slightly lower amount. Why? Because going through the full court process is uncertain, it takes time, and it racks up legal costs for them too. So even after a summons is issued, yes, they are often very open to negotiating. Reduced settlements, structured payment plans. It's always worth exploring, especially if you approach them via a legal representative who can present a proper documented proposal.
Okay. So that brings us back to the core advice, the responsible handling tips. If you had to boil everything down, what are the 3 absolute non-negotiable actions for our listener holding that summons?
1, act immediately. Don't stick your head in the sand. Time is your most critical asset right now. Don't waste it. 2, file the necessary documents on time, especially that notice of intention to defend if you plan to dispute or need time. Meet those court deadlines rigorously. And 3, keep meticulous records. Document every single interaction. These 3 things fundamentally change your position. You go from being a passive victim waiting for bad things to happen to an active participant in the process.
So what does this all mean then? Wrapping up, getting a summons for debt is serious, no doubt about it. It kicks off the formal legal recovery process. But, and this is the crucial part, it is entirely manageable if you take swift, informed action. If you seek professional help to navigate the complexities, especially things like prescription or NCA compliance issues.
Absolutely. And the single most important element often isn't winning some dramatic trial months down the line. It's what you do in those first critical 10 court days. Just by filing that initial document, that notice of intention to defend, you instantly transform your position. You stop the default judgment train in its tracks. You go from being this passive recipient facing automatic consequences to an active participant. Someone the law recognizes has the right to dispute, the right to negotiate, the right to prepare a proper defense. That initial strategic step, that's often the key. It prevents so much potential financial and legal harm later on. It buys you breathing room and options.
Wise words. So if you are currently facing a summons for debt, please remember you don't have to face the system alone. Specialized help is available. Help for navigating the debt recovery process, getting clear legal advice, and securing representation. The most important thing is to take action today.